Good afternoon. Good afternoon.
Uh, Good afternoon, friends. It's always a pleasure catching up to learn the nuances of law as a professional and as a student of law. And especially once you are being given the insights by a professional who has a knowledge par excellence, and at the same time, who has the practical experiences, what could be the law of divorce, etc. As we all know that divorce law in India is vast, and to put it across in 2 sessions is quite challenging. But that's what they say, that once you have a speaker who can put it across in an hour or so or 2 hours, it only shows that how you can funnel across the all issues in the right sense. And that's, they say, makes the difference between a ordinary and an extraordinary person. We all know in a broader sense that there are divorces with mutual consent, a contested divorce, and a void marriages. And what are the grounds on which you can have contested divorce? That is, what are the various grounds as to whether it is cruelty, adultery, desertion, conversion, mental disorder, communicable disease, renunciation of the world, etc. But what is the law on that? You may know the, as what is ordinarily said, we used to have a one judge out here, and ordinarily the lawyers generally read the head notes and say this is the law. He used to say, don't read the telegrams, telegrams can be deceptive, read the entire letter. So in the same way, once you can have the borderlines of what are the various grounds on which one can have the divorce, because ordinarily immediately once you join the law college itself, though it shouldn't be, but people do contact you to say what could be the ground, I am quite disturbed, what are the way forwards. One may have the broader contours to decide upon it, but what are the law and what are the things forward? In these circumstances, we requested Ma'am Aruna Farswani, who is Principal Judge, Family Court, Thane, Mumbai. And they say that challenges in the metro cities are always different, especially during these testing times. Uh, and she had been kind enough to accede to our request. And the way the participants are just logging in the platform as well as on the different forum. And for the first time, we would like to share, though the topic is different, that earlier we used to be only live on the Facebook, but this time we are also live on the YouTube as well as on the Instagram. Over to you, ma'am, and thank you for acceding to our request.
Thank you for introducing me in your own good words. And I also thank for inviting me to join and share a little knowledge with my experience and discussing the broad parameters which are, basically affecting divorce, which is now becoming a parallel institution, I would say, with marriage. As marriages are also being performed, divorces are also increasing. I would first give a little background about marriage to come to divorce, because until there is a marriage, there cannot be a divorce. So, marriage in a broad sense, it would mean legal and social sanction to a union of a man and woman, which would accord them the status of husband and wife, and then a legitimacy to their offsprings. Now, marriage also includes legal rights and duties between the parties. It can be, legal and also social, because marriage is a social institution. For Hindus, marriage is a sacrament. For Muslims, it's purely a contract. And because a meher is given by a man and the female accepts it in presence of two witnesses. For Parsis, also it's a contract, but with a ceremony of Ashirwad. Amongst Jews, it is kutaba. Christians also treat it more as a contract than a sacrament. This marriage institution is a basic foundation of our civil society, and both public and the state are interested in its stability. I would read a paragraph which has really impressed me, which is from Navin Kohli's case, the Supreme Court. Do you want me to give the citations right away, or I can give it later on?
Ma'am, we can share the citations in the WhatsApp group subsequently. Otherwise, the audience will get distracted. You can give this. Otherwise, you can just give the caption. They can be shared with these citations later on.
Yeah, I can give the name of the parties and then,
Yes.
Okay.
Yes.
And
I will
the
have the
detail of
citation with you. We will share it in the WhatsApp group.
Okay, that would be nice because there are a lot of citations. If I
That's
keep
what
on,
I'm saying. Otherwise, there will be very difficult to carve out the differences, whether they have to hear you or whether they have to jot down the citations, etc.
Absolutely. Thank you. Sorry for this interruption, but it made the little things clear. Okay. Now, in Navin Kohli's case, it has been expressed that the foundation of a sound marriage is tolerance, adjustment, and respecting one another. Tolerance to each other's fault to a certain bearable extent has to be inherent in every marriage. Petty quibbles, trifling differences should not be exaggerated and magnified to destroy what is said to be made in heaven. We always say marriages are made in heaven, but now we add to it, but broken on earth in quotes. A Danish proverb says that deaf husband and a blind woman always make a happy couple. Herbert Louis Samuel has stated, I quote, "It takes two to make a marriage, the success, and only one to make a failure." The clashes are not only between the couples, but it's among all the family members and all the other members. Experience says, like I earlier said, that cases for divorces are increasing in every court, and this number is going far beyond. There are various causes which have been recognized by the legislature which would dissolve the marriages in court. There are personal laws like the Special Marriage Act, Hindu Marriage Act, Indian Divorce Act, Parsi Marriage Act, the Dissolution of Muslim Marriage Act, which have recognized various matrimonial offenses for dissolution of marriage. I will take the common causes which are from all these acts, and these causes are the most important causes which have been referred regularly to the courts. They are cruelty, desertion, adultery, and mental ill health. I have put the word mental ill health, but which basically is unsoundness of mind and mental disorder. These are some of these grounds amongst the other grounds. The other grounds can be change of religion, certain vulnerable diseases. The man is not heard for about 7 years. In the other personal laws, there are many more other grounds, which I will discuss in the second part of our session. At present, our Indian legislature for divorce is based on fault theory. No party can take advantage of one's own wrong. In the courts, the most common matrimonial offense which comes is alleged by the parties is cruelty. Now, what is cruelty? Cruelty basically means being cruel. There is no specific definition of cruelty qua matrimonial offense. Through various judicial verdicts, we have got interpretations which have analyzed and explained as to what constitutes cruelty. In Bhagat's case, it has been stated what is inferred as cruelty in a case may not be the same in another case. It can differ from person to person, it can differ from house to house, it can differ from individual to individual. Each case would be different. A particular conduct which may amount to cruelty in one case may not be the same in other because of different set of circumstances and different factors. Cruelty cannot be specifically defined. It relates to the conduct of one spouse with the other. Cruelty for the purpose of the act means where one spouse has so treated the other and manifested such feelings towards the other spouse so as to have inflicted bodily injury or to have injured mental health. It means physical as well as mental. Now, this can be intentional or unintentional. This has to be gathered from the evidence on record, the instances alleged, and all have to be clubbed together, and then a reasonable inference can be drawn that the behavior of the spouse is such and it terms and comes under the concept of cruelty. Lord Reed, in Golin's case, has expressed that as far as matrimonial affairs are concerned, one is not dealing with objective standard. It is not a matrimonial offense to fall below a standard of a reasonable a man or woman, but it is a particular man and a particular woman. Since the conduct of human beings is considered the same, generally are not similar among the human beings. There is no limit to the kind of conduct which may constitute cruelty. The legal concept of cruelty and the kind of degree of cruelty necessary to amount a matrimonial offense has not been defined. In Ravi Kumar's case, cruelty in matrimonial cases can be of infinite variety. It may be subtle or even brutal. It may be by gestures or by words. When at times physical, it can be physical or in any other form. It may be just an attitude or an approach in silence. In such situations, all these factors cumulatively considered and then analyzed whether it amounts to cruelty. Therefore, cruelty as an offense can be in indefinite varieties. In each case, the physical and mental conditions of the parties need to be considered, as all quarrels have to be weighed accordingly to determine the concept of cruelty. Merely because there are allegations and counter allegations, a decree of divorce cannot follow. The same need to be considered in the context which they are made. Even a mere delay in disposing of the divorce proceedings by itself is not a ground. We know that in every court, the proceedings are pending for a long period of time. Every time, some application or the other delays the main proceedings. There are numerous witnesses to be examined. There are times when the counselings have to be done to the parties to either reconcile or mutually settle the matters. So therefore, this long period of the proceedings pending in court, it by itself cannot be a ground. There has to be some extraordinary material on record other than the admitted material to grant divorce if there is no full trial. Now, this concept can see various colors: physical, mental, social, economical, and you can go on and on with it. So, what would be the standard of proof, one would ask oneself? The standard of proof required to establish or prove cruelty is on preponderance of probability and not beyond reasonable doubts as in criminal proceedings. The law has been developing from time to time with the passage as the time goes by. In modern times, the duties and responsibilities have seen a tremendous change. There are varying degrees from house to house and person to person. It also depends upon the lifestyles of the couple, what they're accustomed to, their economical, social conditions, their culture, education level, traditions, and lastly, the human values to which they attach importance. So, slowly, there are so many factors coming in which finally have to be analyzed to consider the conduct of the parties. Now, prior to the amendment of the Hindu Marriage Act 1976, the spouses had to establish cruelty as such a cause which would bring a reasonable apprehension in the mind that it would be harmful or injurious to live with the other spouse. But after the amendment, the spouse has only to establish cruelty on the probabilities. Now, if you take the case of physical cruelty, it's a question of fact and degree. There may be a case where the conduct complained of itself is bad enough and per se unlawful or illegal. Taking the case of demand of dowry. Per se, it's illegal under the law, and due to demand not being fulfilled, we very often see and hear about the ill treatment given to the woman. In these types of cases, where it is itself bad and per se unlawful or illegal, cruelty is established if the conduct itself is proved or admitted. Physical violence is not absolutely essential to constitute cruelty, and a consistent course of conduct inflicting immeasurable mental agony and torture may well constitute cruelty. Even a single act of violence, which is of grievous nature and inexcusable, satisfies the test of cruelty. Wife is not a chattel to be beaten at the whims and fancies of a man. It is not necessary to prove cruelty that there must be many incidents of beating. Some incidents, if established, are more than sufficient. This was observed in Deepavanti Roy's case. A mere plea of the spouse that the other spouse has caused cruelty by using filthy and abusive language cannot be accepted as proved and established. It is expected that the spouse would give particulars. As earlier stated by me, you have to club the instances and incidences together. So these are those particulars which have to be given. Those are the instances and incidences which from which an inference can be drawn that yes, this can be amounted to cruelty. The allegation should not only be pleaded, but proved. And those pleaded allegations must give a rise to apprehension that the conduct amounts to physical or mental cruelty. Specific instances of cruelty must be pleaded. Allegations do not spell out special instances or make such allegations of cruelty which, if considered cumulatively, lead to risible apprehension in the mind that it would be harmful to reside with the other spouse. This has been observed in Vishnu Shankar Pandey's case. So any spouse seeking divorce on the conduct of each other resulting in petty quarrels is not a ground for divorce, though might have resulted in physical or mental ailments. In J. Nanda's case, the mere fact that the parties are unhappy because because of some usual wear and tear or due to some failings in the temper would not be sufficient to spell out a case of cruelty. Cohabitation cannot be destructed merely because of different temperaments of spouses. Defect of temperament must ordinarily be accepted for better or worse. In Vanita Saxena, it has been held that mental cruelty will not depend upon the numerical count of such incidents or only on the continuous course of conduct, but one has to really go by the intensity, gravity, and stigmatic impact of it when meted out even once, and the effect of it on the mental attitude necessary for maintaining a conducive matrimonial home. If any imputations against the character of any spouse is alleged, either by the wife or the husband, without any foundations, and the same is based on mere suspicion, such baseless allegations of illicit relationship amounts to mental cruelty if not proved. Ordinary instances of ordinary instances of quarrels does not amount to cruelty. For example, wife adopting dominating attitude and spending extravagantly or going frequently to a parent's house. This was considered in Tapan Chakraborty's case. Husband had alleged that the wife was quarrelsome with neighbors, friends, and with visitors. She also went to his workplace and demeaned him in presence of other co-workers and students. It was found by the trial court and upheld by the Supreme Court that there was not sufficient evidence to prove the allegations which were pleaded. On the other hand, a criminal complaint was lodged by the wife and the husband was acquitted in the said proceedings. On that ground, the husband had not approached the court alleging mental cruelty, but with regard to her behavior. This was considered by the Supreme Court in Magnash. I'll find it a little difficult because it's a South Indian name, Magnashkari case. This is the latest judgment in 2020. Now here the court held that the allegations were not proved and therefore the husband was not entitled for a divorce. Allegations leveled by husband against wife, which are totally vague and trivial in nature, and occasional outburst by the spouse or use of offensive language once in a while cannot be termed as cruelty. This was considered by the Punjab and Haryana High Court in Avtar Singh's case. The threats given by the wife that she will put an end to her own life or she will make the husband lose his job and have the matter published in the newspapers, persistent abuses and insults hurled at the husband and his parents are all of so grave as the conduct of the wife would impale the husband's mental agony, his job satisfaction and reputation. This is the most famous case, the Dastane's case, where the court held that this conduct and behavior of the wife would amount to cruelty. Threats of committing suicide may also amount to cruelty. Pankaj Mahajan's case. In the case of Joseph, where the husband had resorted to unnatural in the case of Vinit Joglekar, where the husband had resorted to unnatural sexual relationship with his wife against her will, the court held it amounts to cruelty. On the other hand, when the wife refuses to have sex and did not cooperate for a long period of time, she did not perform her matrimonial duties, the court held in Joseph's case that these acts of the wife amounted to cruelty. So refusing to have sexual intercourse for a considerable period of time by the wife would amount to cruelty to the husband. Vidya Vishwanathan's case. In Ashok Kumar Singh's case, the Supreme Court observed where the husband is proved to be impotent and not capable of giving sexual satisfaction to the wife or vice versa, it amounts to cruelty. Mental torture to wife cannot be brushed aside lightly on the ground that there was no physical violence. This was considered in S. Jaykumari's case. Cruelty, however, has to be distinguished from ordinary wear and tear of marital life. It cannot be decided on the basis of sensitivity of a person. It has to be judged on the basis of the course of conduct, which would in general be dangerous for a spouse to live with the other spouse. It has to touch the pitch of severity. Even if the allegations are left to be proved, it would show that the sensitivity of the wife with respect to the conduct of the husband, which could not be termed more than ordinary wear and tear of the family life. This is again discussed by the Supreme Court in Savitri Pandey's case. So to constitute cruelty, the conduct complained of should be grave and weighty so as to draw the conclusion that the petitioner cannot be reasonably be expected to live with the respondent. It must be more serious than the ordinary wear and tear of marital life. Again, this is the observation of the Supreme Court in Manga Devi case. In Narendra's case, it was observed where a wife constantly persuaded the husband to separate from his family and live with her, and to only live with her is not an act of cruelty. The apex court has held that Hindustan has only a marital but legal obligations to take care and maintain his parents when they become old. In normal circumstances, the wife is expected to be with the family of the husband as she becomes integral part of the family. And without any justifiable strong reason, if she insists that the husband should live separately from his family, then that would amount to cruelty. In the case of Srinivas Rao, again the Supreme Court has held that filing of police complaints by itself does not amount to cruelty. But if the allegations are proved to be false, then it would amount to cruelty. Very often in the cases, complaints filed by the wife under Section 498A, in that trial, when it is proved that the allegations are false, then this is considered that, okay, these false allegations are not being established, it amounts to cruelty to the husband because many times he's arrested, he's in the jail for no reason. So this is one ground also which can be considered by the court for dissolution of marriage. Making unfounded, indecent, defamatory allegations against the spouse or his relatives in the pleadings, in the complaints, issuing notices, or in news items which may have adverse effect. In Yu Shri case, the Supreme Court found that the wife was making wild allegations about the conspiracy in the family of her husband to get him remarried for the greed of dowry. She put her husband in an embarrassing situation, including his father, who was also his guru, from which he took music lessons. Wife showed immense dislike to his sadhana in music and exhibiting indifference and contempt to the tradition of teacher and disciple. Spectrum of this fact was held mental cruelty. The other classes which can be considered are, now wife was forced to abort her pregnancy against her will. This also amounts to cruelty. On the other hand, if the abortion by the wife without the consent. Uh, I think I'm back. On the other hand, the abortion by the wife without the consent of the husband and without his knowledge would amount to cruelty to the husband. This was one of the exhaustive incident and illustration given by the Honorable Supreme Court in Sama Ghosh case. It is also held by the Supreme Court in Suman Kapoor's case also. Now, there are times when the husband takes a lot of loans and the creditors keep visiting the house. This disturbs and harasses the woman of the house and the children. I had a case before me where a wife had filed a petition for divorce, saying that the husband was into some business of trading in second-hand cars, and he initially did well in his business, but thereafter, with the passage of time, he started losing in his business. Then, after, he again started some other business. Now, in the meantime, he had taken a lot of loans. So, what he did was he would take his wife from one place to the other, and they would keep shifting their residences. He went to the extent of they went away to Dubai. They stayed with his sister. There she conceived. So she wanted to come back to India for her delivery. Now, even in Dubai, he could not get a proper job. So he again started doing something with loans. He could not repay, so the creditors started knocking the doors. He made an effort to come to India in an illegal way. In that process, he and his wife both were arrested. But his wife, after a month or so, was released because she was pregnant. But the husband was behind bars. Thereafter, somehow he was released and he also came to India. But now this woman had no home in India. So she had to go to Bangalore where his parents were staying. There also she was not accepted. Then he told her to go and stay with some lady friend. She stayed there. Nothing happened. Ultimately, she came to her parents' house for delivery, which was in Bombay, Thane. After the delivery, she really thought she will have to do something to meet her two ends. She did some course, she started working. Now, this man came back from Dubai because he was released and started staying with her at her parents' house. Again, shifting from one place to the other was going on with the child. And ultimately, they settled down in Thane in a rental premises. He had to do something to earn. He again started the business which he was used to, that is the trading of cars, with the business of dealing in other aspects. Now, in this whole process, he again, as he was an habitual person taking loans, he got into again taking the loans. And as usual, he could not repay the loans. What he did, he would go out of the house and send the creditors to the wife. She had to face the music of all his this misdeeds. And the ultimate last straw was when one of the creditors told that they had a daughter, that the daughter should be sold to pay off their debts. And this was something which, nobody would accept. With this last straw, she just saw to it that she moved out of those rental premises, went back to her parents' house, and filed a petition for divorce. The man did not come to the court, and ultimately I granted her the divorce. Because if this man is in the habit and all the time taking creditors and then does not even have the audacity of meeting and facing those creditors, and this poor woman and the daughter has to face all these sorts of things. So that marriage was dissolved. All this act and conduct of the husband, I held that it amount to cruelty. Even when the husbands take loan in the name of their wives and they're not being able to repay this amount, this also would amount to cruelty. This has been held by, in the case of Srimati Manpreet Verma. In another instance, which has been discussed in the case of Raj Talreja by the Supreme Court, a wife filed a petition for divorce on the ground of cruelty. Wife alleged reckless, defamatory, and false allegations against the husband, his family members, and colleagues, thereby lowering their reputation. All the allegations were found to be patently false. Now, this conduct of the wife, alleging false allegations against the husband, they said it amounts to cruelty. And he was entitled for dissolution of his marriage. Newly wedded husband suffering from cancer, hearing ailment, and infertility. Now, suppression of these facts, which came to light on the day of the marriage, the court held, the Madras High Court held, that it is a shock, pain, and sorrow, and a continuous mental agony to the wife, because her future is very uncertain with such type of man. The other thing would be reckless, defamatory, and false accusations against spouses, against the spouse, his family members, and colleagues would lower the reputation in the eyes of his peers. Scandalous allegations by wife against husband. Again, this is something similar to what earlier it was being held by the Supreme Court in the case of Raj Talreja, that all these allegations by against all the family members repeatedly being done amounts to cruelty. This was held, referring to, it was held in Rajan Vasant Revankar case by Bombay High Court. So these illustrations broadly give us this view that what exactly would amount to cruelty after analyzing the conduct. Now, in a matrimonial relationship, absence of mutual respect and understanding between the spouses, which affecting their relationship and often leads to various outbursts of behavior of the spouses, which can also amount to cruelty. This was in Ravi Kumar's case. In Suman Singh's case, divorce being sought on some isolated incidents alleged to have been occurred long past prior to the filing of the petition, and that too have been condoned due to the compromising behavior of the parties, cannot constitute an act of cruelty. Now, in this case, it was that the husband had filed a petition for divorce, and he alleged certain acts of the wife which were at the time of their marriage. And they have cohabited for several years together. They had 2 children from the marriage. And the court said that now, after so many years of marriage and living together, it means you have condoned, forgiven her, for all those acts. So those acts cannot be considered as cruelty. The acts have to be recurring nature, continuing one, and there should be proximity to the filing of petition. There are times when we have proceedings where the other spouse refuses to participate in the proceedings in spite of the notice being served. Now, if the marriage is, with considering the other allegations of the petitioner, the marriage is almost dead, then this itself would constitute cruelty. This was considered in the case of Sukhdena Das case. Unwarranted indifference to the victim's health, victim's health callous, neglect, extreme boorishness, deliberate refusal to cooperate, and calculated harassment in matters touching the household and children of the marriage, and any ill treatment of a grave and serious character may be element which would entitle a spouse to a relief when the cumulative effect of the conduct viewed drawing an inference of cruelty. A husband, knowing that he is suffering from vulnerable disease, insists against the will of the wife, who knows his condition, in having sexual intercourse may be guilty of legal cruelty. A persist course of dishonesty, criminal convictions, which create such reasonable apprehension to the other spouse may well amount to cruelty. Drinking per se is not cruelty, but persistent drunkenness after that, the conduct which is inflicting pain and misery to the other spouse will amount to cruelty. Such drunkenness, coupled with the other act of ill treatment, as it is usually, may be a factor of cruelty. Now, in Vanita Saksena's case, Supreme Court observed that unsoundness of mind as a cause for cruelty can be there. Unsoundness of mind is an independent, separate ground, which we will discuss later. But this conduct of a spouse due to being suffering from unsoundness of mind will amount to cruelty. The spouse may not know that his acts are wrong due to his mental health. But if the conduct is grave, it does amount to cruelty. In such situation, it is not to punish the spouse, but to protect the other spouse from future. In this case, the husband was suffering from mental disorder, the case of paranoid schizophrenia. And due to this suffering of mental disorder, he was not able to have sexual relations with the wife, which led to non-consummation of marriage. The court felt that this act itself amounts to mental cruelty to the wife. The parties were living for 17 years separately. Whilst they were living together, the husband also made an attempt to commit suicide. Now, this conduct of the wife was only discovered by her after the marriage. That he was under constant treatment and observations of the different doctors, which was even prior to marriage. The doctors who were examined as medical witnesses and medical documents which were as evidence brought on record, it all established that he was suffering from mental disorder. At the same time, the husband did not step into the box to submit himself for cross-examination. And neither the wife was cross-examined. So therefore, her evidence went uncontroverted. She gave various specific instances of cruelty, and the court held that it was harmful for her to live with the husband. So her future was considered that it is not going to help her to lead a happy marital life. And considering that, all the aspects, including the humanity, they dissolved the marriage. In Rajesh Kumar's case, against the case of Punjab and Haryana, it was held that vague and general allegations are when pleaded and no particular or specific instances are alleged, nor any evidence to support the allegations are produced that the respondent wife is overly attached to her parents, or she does not know basic cooking, she is rude to him. Now, these factors cannot amount to cruelty. They can be said to be trivial issues which may and do arise between the spouses in their normal marital day-to-day living. An occasional outburst by a spouse or use of offensive language once in a while cannot be termed as cruelty. Even a petition filed by the wife under the Domestic Violence Act would not constitute cruelty. Some other instances I will again narrate. Now, these are various instances which have been observed by various high courts, like attending late night parties by the wife, mere not sending wife to a parental house. These things don't amount to cruelty. The wife spends more time at her parents' house and does not return in time to the matrimonial house. These are all trivial issues. The husband may be irritated, but not an act of cruelty. Demand of wife to go for shopping or have better cosmetics. These acts also are in the normal wear and tear of life. Very often, the husband's stubborn attitude and over expectations from the wife, which are not in accordance with with her dignity and personality, the husband cannot claim mental cruelty. Again, merely because the wife does not cook good meals, she does not do household work, washing clothes, she is quarrelsome on petty issues, these cannot be the components of cruelty. In Samar Ghosh, the Supreme Court has analyzed various international judgments, definitions from various dictionaries, the entire legal judgments, I mean, the legal views of the various courts, including their own court, and then finally came out with certain illustrations. About 14 illustrations they have expressed. I'm not reading all the 14 illustrations, but which they have said that if these acts are there now this judgment is giving a little change in the view of the, um, of the Supreme Court as to what would amount to cruelty. Any act out of jealousy may not be there, but certain acts which are unilaterally taken by either of the spouse may amount to, cruelty, like going for an abortion, not in, having illicit relation, any act which would create anguish, which would not, be in a very peaceful atmosphere of the house. This would all amount to cruelty. I will not discuss, but these illustrations, which are opined, they have themselves said that these are not, exhaustive decisions. They are some of them, and they're not exhaustive. They have also further observed that the concept of mental cruelty cannot remain static. It is bound to change with the passage of time. The impact of modern culture through print and electronic media and value system, etc., the concept of mental cruelty would change. There can never be a straight jacket formula on fixed parameters for determining mental cruelty. Thereafter, there were more illustrations which were added to the Samar Ghosh case by the Supreme Court in case Srinivas. They have given those illustrations like making unsound incident defamatory allegations against the spouse or his or her relatives in the pleadings, filing of complaints, or issuing notices or news items which may have adverse effect on the business prospect of the job of the spouse, and filing repeatedly false complaints and cases in court against the spouse. I would like to share an interesting observation of Honorable Justice Sri Kailash Gambhir in the case of Suman Khanna. His Lordship has observed that parents should not become uninvited judges in the problems of their daughters. Reference to context of the case, it has been further held that parents, instead of putting out the fire, have fueled and fanned it. Now, very often we have seen, at least my experience tells me, that when the matters are before the court, the woman always has been saying, the man always been saying that this woman is only listening to her mother. We don't want her to keep any contact with her parents. Now, that is also an extreme step. But the interference of the parents in the modern times is really becoming one of the causes which will now be considered for dissolution of marriage. It will come slowly. With the passage of time, this is being happening in most of the matters. Interference can be to counsel the couple, interference can be to sort out their disputes and misunderstandings. But if it is adding fuel to the fire, then I think that is going to really burn out the relationship. Now, this concept of cruelty would definitely be naturally be changing
Ma'am, sorry to
depending
disturb.
on.
Ma'am, sorry
Yes.
to disturb. Just keep the paper slightly away. Once you are shuffling, then the noise comes off because of the shuffle of the page. Adjacent to the speaker.
Sorry, come again. I didn't get you. The paper?
Ma'am, once you turn off the pages to give the citations, it is near to the speaker, then the noise comes. Slightly keep the pages slightly adjacent to the speaker.
Okay. So I was discussing about this parent interference, and now with the concept of changing thinking of the young generation, the social and economic lifestyles of the human beings, the concept of cruelty will also be changing. It cannot remain static. And therefore, no straight jacket formula. One cannot categorize the cruel conduct, nor can we compartmentalize. Every act has to be judged in relation to its attended circumstances and mental conditions of the party. It's a debatable subject in different courts, debatable subject, and in different courts, they have given illustrations explaining the meaning whilst analyzing the conduct of a spouse, which could constitute cruelty. Various aspects are considered, like the human nature and the changing social concepts and standard of living. In Shobha Rani's case, again the Supreme Court has observed that among human beings, there is no limit to the kind of conduct which may constitute cruelty. New type of cruelty may crop up in any case depending upon the human behavior, capacity, or incompatibility to tolerate the conduct complained of. Lord Denning, in Sheldon's case, has stated that the categories of cruelty are not closed. This itself, the statement, totally gives us that the concept of cruelty would change with the time. It would change. Various circumstances are to be considered, and most important is the human mind, the human conduct, and the human mind, which would give rise to the circumstances, and considering their education values, their social structure, economic status, and all those things, and then say whether this would really be amounting to cruelty to the other spouse. Now, I would also like to state here that as times are changing, we are shifting from the fault theory to irretrievable breakdown of marriage theory. And I think this would be a most realistic approach. Once the marital relations are broken and there is no emotional bond, the tie is only on paper, then it needs to be dissolved. You can't force couples to live together. And therefore, even when a decree under restitution of conjugal rights is passed and the couples do not live together, you can't force them. The decree is of no consequences, because ultimately, what is the punishment to that decree if not obeyed? Is to attach the property of the husband. There's nothing else. So how does it help, to reunite the couple? And therefore, it's the human mind. It started from Navin Kohli's case, where the expression of irritable breakdown of marriage has been considered as a ground for divorce. But there are some jurists who have expressed their apprehension that introduction of this ground, as it would throw wide open the doors to litigants who would create more problems than solving them. The Law Commission of India, in its 71st report, has dealt with the concept of irritable breakdown of marriage. It has mentioned about it. It has stated that restricting the ground of divorce to a particular matrimonial disability causes injustice to those cases where in situation parties are not at fault, or in a situation marriage cannot survive. In reality, the marriage is dead. A shell out of which the substance is gone, no emotional bonds, their essence of marriage is disappeared. In such cases, there is no reason to keep the marriage alive on paper. This would be the right solution to dissolve the marriage as the marriage has really been irretrievably broken down. Well, this ground is still not available to the trial court and the high court to discuss, to dissolve the marriage. But yes, coupled with some other ground, the court can decide this matter. Now, this has been held in the case of Anil Kumar Jain case, that only the Supreme Court under Article 142 can dissolve this marriage on this ground. There are many more judicial pronouncements on the theory of irritable breakdown of marriage. They have been discussed, and mostly in all the Supreme Court cases. Normally, this ground is also discussed by the high courts, but these Supreme Court judgments are literally trying to state that now the time has come to consider this ground also. In the case of Jordan Dingesh, V. Bhagat, Savitri Pandey, Geeta Mullik, Vishnu Dutt Sharma, R. Srinivas Kumar, and lately in 2020, Munish Kakkar's case. So I have tried to give you various illustrations which have been analyzed and by the various courts and which have given us the directions and the indications that, okay, these acts can amount to cruelty in certain facts and circumstances of the case. But it still says each case is different. It depends upon each case what would amount to cruelty to the concerned spouse. The conduct and behavior cannot be considered only on a particular instance which has been given or on the illustrations given by the apex court or the high court, but the trial court or the courts have to consider overall, cumulatively, the entire matrimonial life and also the entire lifestyle of the couple before we say, yes, this amounts to cruelty. With this, I have given my various aspects of cruelty. From this, I go to the other ground because we are discussing not one ground today, we are discussing 4 grounds, the 4 common grounds. I now go to adultery. Adultery is not, by the word, a ground for dissolution of marriage. It has not been used in any of the sections, in any of the laws. The sections read as, after solemnization of marriage, had voluntarily sexual intercourse with any person other than his or her spouse. In other words, it can be said extramarital sex. Now, prior to the amendment in the Hindu Marriage Act of 1976, the words were living in adultery. But after amendment, it has come, even a solitary instance of sexual intercourse with the other spouse, other than the spouse, married spouse, is sufficient to grant the decree of divorce. Mere allegations of adultery without any details is not sufficient. Mere suspicion as to extramarital sex is not sufficient. An attempt to commit adultery must be distinguished from adultery and will not by itself be sufficient for the relief. First and foremost, any petition which alleges and takes the ground of adultery has to make the adulterer as a necessary party. Non-pleading the alleged adulterer would be hit by non-joinder of necessary party. This is held in Rajesh Devi's case as late as in 2020. It has also been held earlier, but even as late as in 2020, it has also been considered, and it's good law. Now, adultery by its very nature is a secret act. Direct evidence of an act of adultery is difficult. The proof required is to be based on some sort of positive evidence superior to suspicion. To prove factum of adultery, direct evidence is not necessary. It can be proved by oral, documentary, or circumstantial evidence for an inference to be drawn beyond reasonable doubt that the opposite party had adulterous relationship with third person. This view has been taken in Ernest John White case way back in 1958 by the Honorable Supreme Court. It has also been taken by the various high courts, Bombay High Court in Devyani's case, Srivastav's case by Allahabad High Court, Sanjukta's case by Orissa High Court. Now, adultery is generally proved by presumptive proof, which is based A on circumstantial evidence, B evidence of non-X and birth of the child, C contracting venereal diseases, and D confessions and admissions. An attempt to commit adultery must be distinguished upon adultery and will not itself be sufficient for relief. Basically, circumstantial evidence is not normally expected as an accepted rule. The circumstances cannot be universally indicated as characters of parties, situations, state of general manner, and other delicate and slight incidental circumstances in themselves may be important in a particular case. Hence, the general rule would be that the circumstances must be such that a reasonable man can come to a conclusion that there has an act of adultery been committed. Proof must carry a higher degree of probability. Mere suspicion is not enough to avail a remedy under this section. The mere fact that some male relative of the respondent had written some most important improper letters to the wife is not of itself sufficient to prove adultery. This has been held in Chandramohini's case. The presumption of legitimacy is highly favored by law. It is necessary that proof of non-X must be clear and satisfactory. This is what the Supreme Court has observed in Venkateshwarlu case. Hence, the mere premature birth of child is not per se a ground of adultery. The circumstances need to be established to prove adultery. The birth of a child to the wife, where there was no access to her by the husband during the possible period of conception, shows no doubt adultery by wife. But it must be satisfactorily established that the birth of the child was clearly as a result of adulterous intercourse. Proof of adultery must be of such character as would lead a reasonable man to conclude no other inference than the misconduct. In the case of Om Prakash, the Punjab and Haryana High Court has observed that, keeping in view the provisions of Section 112 of the Evidence Act, the fact of non-S can be established not merely by positive or direct evidence, but it can be proved like any other physical act by evidence, direct or circumstantial. Though as the presumption of legitimacy is highly favored by law, it is therefore necessary that proof of non-S must be clear and satisfactory. Under Section 112 of the Evidence Act, there is a presumption that a child is born within 280 days after the dissolution of marriage, if the mother is not remarried. When father refuses to undergo DNA test, the husband would be disentitled to dispute the paternity of the child. This is what has been considered by the Supreme Court in Dwarika case. Now, when the issue about excess and non-excess is there, always a thought comes for a DNA test. The Supreme Court in the case of Nandlal's case has held that when it comes to paternity of the child, DNA test prevails over the presumption of the conclusive proof under Section 112. Section 112 of the Evidence Act was enacted when there was no scientific advanced DNA test, but now with the advancement of science, the result of DNA test is said to be scientifically accurate. Since the truth or fact has to be known, there can be no room for presumption. Interest of justice is best served by ascertaining the truth. The court should be furnished with the best available science and not be left upon to bank on presumptions. The court has discussed the distinction between the legal friction and presumption of fact and has finally held that in a situation in which the DNA test report is available, though in conflict with the presumption of conclusive proof of legitimacy of the child under Section 112 of the Evidence Act, this test will prevail. There are certain instances which are also being considered which do not amount to amount to adultery. That is merely going to pictures, dining in a hotel with a third party, without evidence of affection. Behavior between parties would not necessarily lead to this guilt. When the husband makes allegation of non-access and birth of the child during the said period and alleged leaving the matrimonial home by wife, the allegation of non-access and leaving of matrimonial home by the wife should not be accepted without corroborated testimony of the complainant. This is observed in the Kismatta case by the Supreme Court. Bombay High Court has opined in the case of A versus B that the evidence of detectives has to be accepted with caution, and unless there is some collaboration, it is hazardous to accept the evidence of such agency in toto. It is very easy to levy allegations of adultery, but to substantiate with such allegations, reasonable and cognate evidence has to be produced. Being seen is not required. The important requirement is day, date, and time, which should come on record so that the person who has alleged to have indulged for adultery can have the opportunity to defend this case and explain the same. Therefore, adultery as an offense is not easy to establish. It is, with the circumstances, it is to be established with non-X. Now, non-X can be collaborated with the DNA test report. Direct proof is very difficult, but it has to be something where the evidence is such that a normal person would also consider, yes, these circumstances will lead to establish that the act of adultery has been committed. It's only then it can be said that the spouse is, has committed this offense and is guilty of the offense. So from this, I go to the next aspect, that is basically the condonation of the offenses, because it's the cruelty and adultery which are the two offenses which legally are being discussed, which can be condoned. Condonation of offenses under section 23 2b of the Hindu Marriage Act has specified cruelty and adultery. The Hindu Marriage Act has not defined condonation. The general accepted definition meaning would be forgiveness and restoration with knowledge of all material facts. It is regarded as forgiveness, express or implied, for a breach of a matrimonial offense with an implied condition that it would not be repeated. Dastane's case, reference has been made to the offense of cruelty, which has been examined, and the doctrine of condonation has been explained that it means forgiveness of matrimonial offense and restoration of offending spouse to the same position as he or she occupied before the offense was committed. To constitute condonation, therefore, there have to be two things: forgiveness and restoration. The parties to lead a normal sexual life, even after the series of acts of cruelty by one spouse, is a proof that the other has condoned the cruelty. The Supreme Court has further observed that though intercourse is not necessary ingredient of condonation, in many judicial pronouncements, it has been seen that when the couple cohabits, are blessed with a child after the act of cruelty, then the doctrine of condonation is inferred. It is also said reconciliation is a test of condonation. If the husband and wife have started cohabiting between them after the knowledge of the act of adultery, the petition on the ground of adultery can be rejected. This is in Chandramohini Srivastava's case. But if the offending spouse continues to indulge in adultery, then there cannot be condonation. Cohabitation with one's wife against her will does not amount to condonation of act of cruelty committed earlier by her husband. This is Rita Kishore case. In Avinash Eknath Nikhalji's case, an undertaking given for a good conduct by wife, condonation in such circumstances would always be subject to implied conditions that offending spouse would not commit a fresh matrimonial offense, either of the same variety or as the one condoned or of any other variety. The undertaking need not be complied. Fresh petition for divorce can be filed. Husband then can rely upon the circumstances which were committed by the wife in the first round of divorce. In this case, the husband had first filed a petition for divorce on the ground of cruelty, where he had alleged certain allegations against the wife. Thereafter, they compromised. The wife gave an undertaking that she will not, misbehave, but she did not abide by the undertaking. She continued with her behavior, and then the husband again filed a second petition for dissolution of marriage. Now, in those circumstances, the court held that the husband could again go back to the old instances which he has alleged against the wife, which would amount to cruelty as per him. At the same time, we also have res judicata. Now, res judicata would be when there is a decision given on the allegations. Now, in this case, there was no decision given, and the wife had gone back to her old behavior. But in res judicata, if already decisions are given, I'm just giving you the basic principle, then we cannot come back with the same allegations. So condonation would be a couple forgives each other, forgets the past, starts a fresh life, restore their marital relationship, live a normal, happy marital life, or live a normal life as a husband and wife, then the acts are condoned. Now, this can be only as cruelty acts or adultery acts. These acts have to be, I mean, with knowing that these acts have been committed, they still want to save the marriage and continue their life. And that is why they say it is condonation. From here, I go to the next ground, desertion. Now, word desertion refers to abandonment or giving up. It means intentional abandonment of one spouse by the other without his or her consent and without reasonable cause. Therefore, four conditions need to be fulfilled. There should be a factum of separation, but there is a condition precedent that it should be 2 years, which is a statutory requirement. The most important is the intention to bring the marital life to an end. And lastly, without consent of the other spouse and without reasonable cause. The first two conditions are essential for the deserting spouse, and the last two are for the deserting spouse. The question of desertion is a matter of inference to be drawn from the facts and circumstances of each case, and those facts have to be viewed as to the purpose which it is revealed by those facts or by the conduct and expressions of intention, both anterior and subsequent to the actual acts of separation. This has been viewed by the Supreme Court in Sanat Kumar Agarwal's case. It can also be said total repudiation of the matrimonial obligations. Desertion need not be withdrawal from a place, but it is withdrawal from state of things. It therefore means withdrawing from the matrimonial obligations. That is, not permitting or allowing and facilitating the cohabitation between the parties. It is not a single act complete in itself. It is a continuous course of conduct to be determined under the facts and circumstances of each case. If a spouse abandons the other in a state of temporary passions, for example, anger or disgust, without intending permanently to cease cohabitation, it will not amount to desertion. This is the view in Savitri Pandey's case by the Apex Court. The explanation to this section of desertion has widened the definition. It also includes willful neglect of the petitioning spouse by the respondent. One effect of including willful neglect in the meaning of desertion is that willful neglect of one spouse by the other is sufficient to establish abandonment or expulsion conduct and amounts to proof of animus discendi, that is, by consent bringing an end to the marital ties on the part of the latter. Willful neglect to maintain the wife without reasonable cause would be desertion. It is a conscious disregard of the matrimonial obligations and duties. Desertion, for the purpose of a decree, commences as soon as animus discendi coexist with physical separation. It is not necessary that they should commence at the same time. De facto separation may commence without the necessary animus, and later the spouse may decide to leave his or her partner permanently. It is from that point of time from where the period of desertion shall be counted. This has been considered in Neeta's case. If a deserting spouse takes advantage of the period and later decides to return to the deserted spouse by a bona fide intention to resume cohabitation before the statutory period lapse or immediately thereafter, and the deserted spouse, without reasonable cause, refuses to accept the offer of, then it would be the latter who would be a in desertion and not the former. This has been considered in Bipin Chandra's case. This concept was further elaborated in Lakshman Uttamchand Kriplani's case and Rohini Kumari's case. In the said case, it has been held that desertion does not imply only on a separate residence and separate living, but it is also necessary that there must be determination to put an end to the matrimonial relationship. In Lakshman's case, it has been held that the inference may be drawn from certain acts which may not in any other case be capable of leading to an inference that it is to say that the facts have to be viewed as to the purpose revealed by those acts or by the conduct and expression of intention both earlier and subsequent to the actual acts of separation. Desertion is a continuous offense, and hence the factum of separation and animus descendi should be continued during the entire statutory period of 2 years immediately preceding the presentation of the petition. Mere abandoning the matrimonial house may not amount to desertion unless it is shown that the deserting spouse had intended to permanently bring the marital ties to an end with the consent and reasonable cause. If the spouse is living separately because of his or her job or without any intention to bring marital relationship to an end, it would not amount to desertion. That is, the factum of separation is there, but the intention is not there. Again, if a spouse abandons the other in a state of temporary passion or anger, without intention to bring an end to the marriage, it would not amount to desertion. This is Shobhan Singh case. In a case where a husband was in army, he did not take his wife to the place of his posting. Wife decided not to stay with his parents and she resided with her parents. This will also not infer desertion. This was in Vikas Sharma's case. There is another concept which is considered in desertion, that is the rule of constructive desertion. Now, this is well established that a spouse may be guilty of such misconduct as would render the continuance of matrimonial relations so unbearable that the other spouse feels compelled to leave the matrimonial house. And in such situation, it is the former who is the deserter and not the latter. This is observed by the Bombay High Court in Mr. X versus Mrs. Y's case. If one considers that there is no difference between a husband who leave his wife with an intention to bring an end to end to cohabitation and a husband who was with an intention by his misconduct compels his wife to leave the matrimonial house, thereby brings an end to cohabitation. But there is a small rider. The misconduct must be grave and convincing and not on petty issues which are in the normal wear and tear of matrimonial life. Therefore, who leaves the house first is not important. It is basically the intention which is very important to consider the concept of desertion. Where there is demand of money from the wife, she withdraws from the society of the husband, it cannot be said she is withdrawn without reasonable cause. But where there is no such demand and the wife does not respond to the efforts of her husband to fetch her back, even his notices, then such circumstances support the allegation of desertion. Desertion can also be proved while the spouses are living under one roof. If the petitioner himself or herself refused cohabitation with the other respondent, then there is desertion. Petitioner must show that he or she are not taking advantage of one's own wrong. If proved that petitioner did not permit cohabitation for consummation of marriage, in absence of cohabitation for consummation of marriage, petitioner is entitled for a divorce decree on the ground of desertion. This is the opinion of the Supreme Court in Savitri Pandey's case. Now, another instance. If the wife is living with the parents with the permission of her husband, it is not desertion. Wife, even when there are conditions of terror created for her and she has left the matrimonial home, again, it is not desertion which can be claimed by the husband. When the husband makes several allegations on the character and chastity of his wife, who is forced to leave the house, it cannot be said she is deserted. She has deserted the husband. The principle of constructive desertion is applicable in all these instances. If the husband is living in adultery, wife has a good cause to live separately. It does not fall in the ambit of desertion. Husband has performed second marriage and has himself forced the wife out of the matrimonial house. No relief of desertion can be given to the husband. Wife goes to her parents' house for delivery with the intention to return to the matrimonial house after the delivery. The conduct of the husband is considered that he does not visit the nursing home. He neglects the child and the mother. He treats them with cruelty. He does not make any financial arrangements for them. He does not even bother to go and fetch the wife. Now, in this situation, the wife has a just cause for living separately. But the husband cannot claim desertion. It cannot be said that she has deserted him. This is the view in Ramchandra Lamba's case. The question of desertion is a matter of inference to be drawn from the facts and circumstances of each case. And those facts have to be viewed as a purpose which is revealed, and those facts are by conduct and expressions of intent, both interior and external. This I have already been saying so. Therefore, to constitute desertion, firstly, there should be cohabitation by the parties. It's an essential in a valid marriage. There can be no desertion without previous cohabitation between the parties. The basis for this theory is built upon the recognized position of law in matrimonial matters that no one can desert who does not actively or willfully bring an end the existing state of cohabitation. Now, we always have been seeing that petitions for divorce are filed cruelty on grounds of cruelty and desertion. Both grounds are taken simultaneously. Now, the same conduct could constitute a charge of constructive desertion and could also be an element of charge of cruelty. Very often, the facts are misled. The petitioner has to prove both the grounds. Petitioner also has to establish that he or she is not taking advantage of one's own wrong. To conclude, desertion is not withdrawing from a place, but from the state of the matrimonial obligations. It is not specific act, but a course of conduct which exists independently of its duration, but as a fact on which a petition for divorce may be formed. It is not a single act, but which in itself is complete, and each case will depend upon its own facts and circumstances. So, the most important factors for the ground of desertion is the intention of the party to bring the marital ties to an end. It can be living under the one roof, it can be living separately. But until that intention is there, it cannot be said that the one spouse has deserted the other spouse. or the principle of constructive desertion, where like the wife is compelled to live separately. Now, if she's compelled to live separately, she cannot be, thrown with the offense of desertion. It is not she who has deserted, it is the husband who has been deserting her. It is he who does not want her back. Um, I have one more ground, Mr. Vikas. Should I continue? Should I continue? There is one more ground about
the next webinar which we are holding on the next Thursday, we can take it on that part.
Okay, because that was the this incurable of unsigned mind, which I thought I could have completed today, but I know it's
how much time it will take, approximately?
about 10-15 minutes. I'm not going to take.
Then we can complete this.
Yeah, so that we can complete these 4 important aspects.
Yes, ma'am. It's fine.
Okay. Yes. And the last, which is one of the most important cause matrimonial offense, is incurable of unsound mind. Now, this every personal law has been considering this section, this ground, and this section itself says that that this unsoundness of mind, it should be incurable. The expression incurable of unsound mind, as used in Matrimonial Causes Act in 1950, in the Act of 1950, it was considered in Weissol's case, and it has been observed that in deciding whether a person is incredible of unsound mind, the test would be whether by reasons of his mental condition he is capable of managing his own affairs, and if not, act whether he can hope to be restored to a state in which he will be able to do so. The capacity to be required is that of a reasonable person. In Kartika Chandra's case, Calcutta High Court has observed the mental disorder must be of such degree which makes it impossible for the marriage to continue. A person who is incapable of managing himself and his affairs, including the problem of society and of married wife, can be said to be a person of unsound mind. All mental abnormalities are not recognized as grounds for grant of divorce. Some are curable. The unsoundness of mind and mental disorder require assessment of the degree of the mental disorder. The degree should be of such an extent that the other spouse seeking relief cannot be reasonably expected to live with it. The burden is upon the spouse claiming these facts. This is considered by the Supreme Court in Ram Narayan Gupta's case. This case has been basically a very important case in consideration of this section, that is the unsoundness of mind. And the court has expressed various views on the subject. A person who can understand his affairs, though is feeble-minded, and a person of dull intellect is not a person of unsound mind. Oversensitiveness of mind can also not be equated with unsoundness of mind. In Alka Sharma's case, a person suffering from schizophrenia will start showing progressive deterioration in the level of performance at work. The behavior would be inappropriate, strange, and odd. In a case where a wife's conduct is such that she urinates in the presence of family members, she suffers from similar other acts, a kind of schizophrenia from which she suffers, husband is entitled to a degree. In T. Hari Kumar Naidu's case, it has been held that when the evidence is available with the petitioner, the refusal of the respondent for medical examination by doctors may lead to adverse inference. In a case where the wife denied the illness and refused treatment, it was held that the husband is entitled for dissolution of marriage. In Sudhir Saigal's case, it was held that even a certificate of doctor may not be sufficient to prove mental disorder. In Usha Gupta's case, it was considered that a few strong instances indicating short temper and somewhat erratic behavior on the part of the spouse may not amount to his or suffering continuously or intermittently from mental disorder. This is another very important case which is laid good law, that is Sharda's case. The Supreme Court in the said case has held that the court has the power to order a person to undergo medical test. Such order would not violate the right of personal liberty under Article 21. In spite of the order, the spouse refuses to go for medical examination, then the court can draw an adverse inference. The basic concern of the court is to find out as to whether a person who is said to be mentally ill could defend himself properly or not. Whether the spouse requires a treatment or not can be found out only when he is properly examined by the qualified psychiatrist. It may not be necessary for the spouse to submit himself for any blood test or pathological test. The apex court has concluded 3 points. Matrimonial court has power to order a person to undergo medical test. Passing such order does not violate Article 21. Such power of the court should be exercised if there is strong prima facie case that there is sufficient material before the court. Then in Tarlokchand's case, it has been held that the material fact of the wife being a patient of schizophrenia was not disclosed to the husband before marriage. It would amount to matrimonial fraud, and therefore he was entitled to the decree. Again, I go back to Ram Rana's case, where the court has held that the court should be cautioned of the section and of section 13(1)(I)(3), that is the Hindu Marriage Act they have been referring, which does not make a mere existence of a mental disorder of any degree sufficient in law to justify dissolution of marriage. So they say that only, there should be a sufficient degree. Only the allegation that the other spouse is suffering from mental disorder is not enough. It has to show that the degree is so grave that the spouse, complainant spouse, cannot continue to live the marital life. In Vanita Saksena's case, the court has held, in which I would give a little background of this case, was that the husband was suffering from schizophrenia, though the wife knew him prior to marriage, but this fact was not known to her. After marriage, she discovered that he is being suffering from different mental disorders. He is a schizophrenic patient. He is not being able to consummate marriage. He has made an attempt to commit suicide. So all these acts which were being done, she was, at the instance of the mother of the husband, the husband would beat her. When she complained to the mother of her mother-in-law, the mother-in-law said, you should tolerate all these things. So then the court felt that the court has in fact discussed what is schizophrenia, what are the medical evidence to be considered. It has discussed about the disease and what should be known about it. It has said that schizophrenia is one of the most damaging of all mental disorders. It causes its victim to lose touch with reality. They often begin to hear, see, or feel things that aren't really there, that is hallucinations, or become convinced of things that simply aren't true, that is delusions. In the paranoid form of this disorder, they develop delusions of persecution or personal grandeur. The first signs of paranoid schizophrenia usually suffer between the age of 15 and 34. There is no cure, but the disorder can be controlled with medications. Several attacks may require hospitalization. A psychotic lacks insight, has the whole of his personality disordered by illness, and constructs a false environment of his subjective experience. Psychotic symptoms include hallucinations, hearing voices, or seeing things. These symptoms occur during acute or psychotic phases of the illness, but may improve during periods of remission. A patient may experience single psychotic episode during the course of the illness, multiple psychotic episodes over a lifetime. Thereafter, delusion is defined. Ideas of delusions or reference are not confined to schizophrenia, but can occur in depressive illness and psychogenic reactions. The causes of schizophrenia are still under debate. A chemical imbalance in the brain seems to play a role, but the reasons for the imbalance remain unclear. If any family member is with the illness, there is the possibility of the others becoming. Stress does not cause schizophrenia, but can make the symptoms worse. Schizophrenia is also defined as a chronic, disabling mental illness characterized by psychosomatic symptoms, disordered thinking, emotional blunting. It generally develops in late adolescence and early adulthood. Initially, symptoms gradually appear and include feeling of tense, difficulty in concentrating, difficulty in sleeping, and social withdrawal. So, what is schizophrenia? What are the causes, the effects? This has all been discussed in Vanita Saksena's case. I'm not reading everything because it will take a lot of time. Now, in the case of Prathama Kumar Maiti, that is the Calcutta High Court, has held that mental disorder of the wife, even if proved, cannot by itself warrant a degree of divorce. It must further prove that it is of such nature that the husband is not expected to live with her. That is what I earlier said, the degree of the ailment. In another case, the Allahabad High Court has held that when it comes on record that the wife has improved her education qualification and is taking care of the children, an apprehension of the husband that there is a danger to his life and children's life is not borne out. The court has held that inability to manage one's affairs is an essential attribute of an incurable unsound mind. In Sher Singh's case, Punjab and Haryana High Court has observed that the husband did not produce any medical evidence to prove that the wife was suffering from any mental disorder. Neither the doctors stated so. Though the husband alleged that the wife was mentally ill, but he did not get her checked from any mental hospital. The court held that the refusal to do household work or sleeping for a long time could not be mental illness. To establish medical testimony is of considerable assistance. There was a case where the husband filed a petition on the ground of mental disorder of the wife after 13 years of marriage. He alleged that the wife took off the bridal garland on the marriage day. She also drank entire milk without offering a portion thereof. She refused to take food and was in the habit of drinking water with the turmeric powder. She applied castor oil to her hair and bathed twice a day. Now, these acts, the court held that they cannot be a result of mental disorder. This was considered by the Karnataka High Court in Jay Sudhakar Shenoy's case. Mere mental disorder in itself would not be entitled for the relief under the Act. Mental disorder of such a degree which would be impossible to lead a normal marital life, or it's unreasonable to expect a person to continue to live life with the other spouse in such condition. There is difference between mental stress and mental unsoundness. If a spouse is unable to receive proper treatment or mental stress which would cause due to the conduct of the other spouse, the mental strain would aggravate and affect the behavior of the spouse, but it cannot be construed as mental disorder. Therefore, unsoundness of mind, which is mental disorder, it cannot be just with allegations. The conduct of the party, the medical evidence, and finally, the degree should be such that it satisfies that yes, the complaining spouse cannot live with that person and therefore is entitled for dissolution of marriage. Lastly, just 2 minutes to conclude, I would just add one more aspect, that is customary divorce. Now, for a customary, we have very, in our country, customary divorce in remote places or in rural areas is very common. But the court does not recognize customary divorce until that is been proved. Now, for a valid custom divorce, it is observed that it should be long and it should be ancient. It cannot be created by an agreement. In Subhash Chandra Sharma's case, it was held that the petitioner required to lead cognate and convincing evidence to prove and substantiate the arguments made in the proceedings. No evidence to show existence of any practice of customary divorce prevailing in community. Custom is defined by the court considering section 29(2) of the Hindu Marriage Act. It is a rule which in particular family or a particular class of community or in a particular district has for long usage of time obtained, and then it is obtains the force of law. It must be ancient, certain, reasonable. Then the court can consider that yes, it is a customary divorce. It has to be construed strictly and should be established by evidence. This has been observed in the case of Shalini Dhanraj. Now, I just wanted to give you this customary divorce because there have been cases where the parties enter into an agreement. I mean, they're misled, they enter into an agreement and then they say, yes, the marriage is dissolved. But when they come to the court, if their second marriage is in trouble and the party takes advantage that the first marriage is not dissolved legally and therefore declare my marriage as null and void. So therefore, these customary divorces cannot be considered per se until they have been established with a long period of time existing in their community, district or society. Thank you, Mr. Vikas. I think I have covered the first 3-4 important causes of dissolution of marriage. It's taken a long time. I'm sorry, I've taken a long time.
No, not at all. Not at all. Only once the speaker takes the long time and he's explained all, then we don't take the questions because we feel that the majority of the participants have understood the things. Rest we all lawyers are quite clever to the effect that we ask the queries so that they can resolve the questions from the best person to be asked. and even the students can do that. But once there is a session which is explained elaborately with these legal provisions as well as how to proceed further. So one is always actually glued with that. And the participants being glued, despite the fact that the office hours started or the professional, the second part, because they say that first you, in a lighter way, they say that after 5:30, it is the OPD time for the lawyers.
Okay. But during this pandemic period, what would happen? I don't think there should be any, or you all are all very active.
Once you have to appear for the virtual courts, the only issue is the cases which were pending prior to the lockdown. They have not been taken up, but virtual courts cases are being filed. That's not the issue. Undoubtedly, the filing is not to that extent, but still it is there.
Well, we have a lot of filing, and we are disposing of lot of my matters also through virtual this.
Recording of evidence, etc. Recording of evidence and
not recording of evidence, but we are filing is going on, and then we are disposing of mutual consent petitions, convert petitions, ex parte matters. Those matters are being taken.
That's what I'm saying. That's what I'm saying. Some offshoot of the litigation is not there. Let's assume there's no evidence. Then the civil revision for that closure of the evidence or some aspects are not being done. And let's assume the final case has not been done in an MSCT divorce. Then you are not filing an appeal. Writ petition, I don't think pan India there's. Yes, of course, like filling of the posts are not there. In the same way, in a criminal case, you are having the bails, but you're not having the revision out of some order, quashing of the FIR. So that way, that's my presumption.
So those cases in the district courts are being
Yes.
those cases
So
are taken in the district court.
Yeah, no, but I'm saying the cross-examination part, closure, 319, 311 aspects, the litigation which can make the lawyers move around. That's not happening, but some part of litigation is there. A slow movement is there. But they all say that they are all on the floodgates. Once the things become normal, that you can't hold that. So good days will begin for the professional. Otherwise, also for the society at large also. Let's assume there's a difference and they want to settle it. Maybe
yes,
it's not that mutual is always there. With the flux of time, with mediation process, etc., sinking of differences, with time, once you're coming to the court, you find the child out there. There's a difference between that. You iron out the creases. So it has its own advantages in that way. It's not that litigation, but you can settle the aspects like mediation, 4, 5, 6 cases in a one shot, which is cleared off. So we won't take the cases since it becomes the off. We are not taking the questions as of now. It's already around 6. So next session on the masterclass on law of divorce in India, part 2, next Thursday. Again at 4 p.m. Ma'am has consented to give the second side. As they say, every coin has 2 sides. We will see the second side of the coin, not on that aspect.
Not second side, Mr.
Continuative. I'm saying it's a continuative.
Other laws.
Yes, others law. It's only in the lighter vein. I'm saying it's
yes.
Not giving that. I'm only saying part 2. It's not even a sequel, but it's a part 2. You have a more hang of that. We have touched some view. A 2D view has been seen. 3D view will be seen on the next day. We have the holistic view of the entire law of divorce. So everyone, we are quite happy that you are encouraging us to keep on doing the webinars so that there could be knowledge sharing. These are the practical aspects which help us to learn the nuances of the law. Tomorrow, in the pursuit of our webinars, the topic would be media on trial by Mr. Justice Vijay Jain, who has been the former Chief Justice of Punjab and Haryana High Court. Along with him would be Mr. Atullah Khanpal, Senior Advocate and a former President of Punjab and Haryana High Court. It's not media trial, but it's a topic different. We have kept a topic media on trial. Whereas now they are also under scanner as to whether they can publish everything, whether they are scot-free, they can do everything. So a different flip on a different topic, media on trial. So we will wait for all of you. And thank you, ma'am, once again for giving the insightful session. We are so happy and